Welcome to Divorces in North Carolina. You just got divorce papers, now what? You have a spouse guilty of emotional neglect. Proving that he or she is an unfit parent can be challenging, and this video provides some insight into how to tackle it. This video considers the factors the court uses to make a decision for your child's best interest. Please share and subscribe if you find value in this video. Ever wondered what evidence you need to prove a parent is unfit in a custody hearing? You're not alone. Family law's custody disputes are one of the toughest puzzles to solve. When a parent's fitness is questioned, the stakes are even higher. In these situations, the importance of evidence is paramount. It forms the basis of any custody hearing and guides the judge's decision. It's the foundation that can tip the scale in your favor. In legal terms, an unfit parent is one who, due to their actions or conditions, cannot offer a safe and nurturing environment for their child. However, it is crucial to remember that being an unfit parent in the eyes of the law is not a moral judgment. It's a legal term to protect the child's welfare. Proving this in court requires careful collection and presentation of evidence. We're here to walk you through this process. We'll discuss the types of evidence that carry the most weight, how to document incidents effectively, and how to use witnesses to strengthen your case. Navigating a custody dispute can feel like crossing a minefield, but with the right guidance and preparation, you can get through it. So buckle up and prepare for a deep dive into the world of custody hearings. We'll delve into the step-by-step process of gathering evidence to prove a parent is unfit. Stay tuned. Scene script. First, it is crucial to understand what criteria the court uses to determine if a parent is unfit. When it comes to making decisions about child custody, courts consider a variety of factors to determine whether a parent is unfit. These factors are not taken lightly, as they directly influence the welfare and development of a child. One of the primary criteria is neglect. This can manifest in many forms, such as failing to provide basic needs like food, clothing, and shelter, or not ensuring the child's safety. Emotional neglect is also a significant factor, which includes ignoring a child's emotional needs or not providing adequate emotional support. Another crucial criterion is abuse. This can be physical, emotional, or sexual. Physical abuse includes any action that harms a child physically, while emotional abuse can be anything from constant criticism to manipulation and control. Sexual abuse, of course, is any sexual act forced upon a child. Courts take allegations of abuse extremely seriously. Addiction is another factor that courts consider. If a parent has a severe addiction to drugs, alcohol, or any other substance that impairs their ability to care for their child, it can be grounds for being deemed unfit. This also includes if the parent's addiction leads to illegal activities that endanger the child. The court also looks at the parent's mental and physical health. If a parent has a mental or physical condition that prevents them from adequately caring for their child, it may be seen as unfit. However, it's important to note that not all mental or physical conditions lead to this conclusion. It largely depends on the specific situation and how it affects the child. Lastly, the court considers the parent's willingness to foster a positive relationship between the child and the other parent. If a parent consistently hinders this relationship, it may be seen as unfit behavior. Knowing these criteria will guide you on the type of evidence you need to gather. Let's delve deeper into the process of gathering evidence in our next segment. Now that we know what makes a parent unfit, how do we go about gathering evidence? Well, let's dive right into it. Evidence is the cornerstone of any legal proceeding. In cases of child custody, it becomes even more crucial as it directly impacts the welfare of a child. So, what constitutes as evidence in such a situation? It can be a wide array of documents and records that help paint a clear picture of the child's environment and the parent's behavior. First off, medical records are a potent type of evidence. They can provide insights into the physical health of the child, indicating whether there's been any neglect or abuse. If a child has frequent unexplained injuries, or if there's a pattern of delayed medical care, it could be indicative of an unfit parent. Next up, we have police reports. These documents can be very telling. They may reveal instances of domestic violence, substance abuse, or criminal behavior, all of which could potentially put a child's safety at risk. School records are another valuable resource. They can provide a snapshot of the child's academic performance, attendance, and behavior. If a child is frequently absent or their grades are consistently poor, it might suggest issues at home. Letters from teachers or school counselors noting any concerns can also be powerful evidence. Now, you might be wondering, how do you legally obtain these documents? Medical records can usually be requested directly from healthcare providers. They're obligated by law to provide you with a copy, so long as you have the necessary permissions. For police reports, you can usually request them from the police department that handled the case. There might be a small fee, and you may need to provide a reason for the request, but these records are generally accessible to the public. School records can typically be requested directly from the school or the school district. You may need to provide proof of your relationship to the child, but as a parent, you have the right to access these records. However, remember to respect privacy laws and regulations while gathering these documents. Unauthorized access or use of personal information can jeopardize your case. Lastly, it's important to organize your evidence systematically. Keep a dedicated file for each type of evidence and make sure to note down dates, times, and any other relevant details. This will not only help you keep track of everything, but also make it easier for you to present your case when the time comes. Remember, gathering evidence is a meticulous process, but it's worth it when it comes to your child's welfare. You're not just collecting papers and records, you're building a case to ensure the best possible environment for your child. After all, as parents, isn't that what we all want? In the process of gathering evidence, documenting incidents plays an integral role. You may wonder, how can this be done effectively? Documenting isn't just about remembering things, it's about crafting a robust record of events that can serve as persuasive evidence in court. A well-documented record could be the game changer in a custody case. Let's delve into how you make this happen. First off, consider keeping a journal. It might be a bit old school in today's digital age, but it's still a potent weapon. Write down every incident that makes you question the other parent's competence. This could be instances of neglect, abuse, or any harmful behavior towards your child. Include dates, times, locations, and go into as much detail as possible. Remember, the devil is in the details. Next, consider using pictures or videos to document incidents. Visual evidence can have a powerful impact. If you observe physical signs of abuse or neglect, or the other parent leaving your child in a dangerous situation, capture it on your camera or video when it's safe. But make sure these are taken ethically and within legal boundaries. Recording conversations can be helpful too, but be aware of the legal ramifications. In some places, it's illegal to record without consent from all parties involved. So, familiarize yourself with your local laws before pressing the record button. Also, pay attention to emails, text messages, and social media posts. These could provide a glimpse into the other parent's behavior and attitude towards the child. If you spot any disturbing messages or posts, save them. Besides documenting incidents, keeping records of interactions with professionals involved in your child's life is vital. This could include teachers, doctors, counselors, and social workers. Their observations could bolster your case. Keep your records updated. The fresher your evidence, the more weight it holds in court. Time can blur details and distort memories. Regular, consistent documentation ensures your evidence remains clear and credible. Lastly, safeguard your records. They are critical pieces of evidence for your case. Have multiple copies, store them at different places, and consider digital storage for added security. In conclusion, effective documentation involves being thorough, consistent, and organized. It's about crafting a persuasive narrative to support your custody case. It's about demonstrating, not just narrating, why you believe your child's well-being is at risk. Remember, when it comes to building a formidable custody case, your pen, your camera, or your voice recorder can be your strongest allies. Proper documentation can significantly bolster your case. Another potent form of evidence is witness testimony. But who can be a witness? and what should they testify about? When we think about witnesses, it's essential to remember that a witness is anyone who has first-hand knowledge about the situation. They've seen or experienced something related to the case, and their testimony can provide valuable insights. So let's explore who these witnesses could be and what they might testify about. First, let's talk about teachers. Teachers spend a significant amount of time with children. They observe them in a variety of situations and can provide insight into their behavior, performance, and emotional states. A teacher can testify about noticeable changes in a child's demeanor, academic performance, or social interactions. They might also share any concerns or observations about the parents' involvement in the child's education. Doctors or medical professionals are another great resource. They can provide evidence regarding the child's physical health and well-being. They might discuss any signs of neglect or abuse, or changes in the child's health that could be linked to parental behavior. They could also testify about a parent's compliance or non-compliance with medical recommendations. Neighbors and friends can also be vital witnesses. They can testify about what they observe in the family's day-to-day life. This could include interactions between the parent and child, the parent's behavior, or any concerning incidents they've witnessed. Family members are often overlooked as witnesses, but they can provide some of the most informative testimony. They typically have a deep understanding of the family dynamic and can discuss patterns of behavior over time. They can testify about the parent's fitness or lack thereof, based on their personal experiences and observations. Even professionals like psychologists, social workers, or family therapists can be called upon as witnesses. They can provide expert testimony about the potential impact of the parent's behavior on the child's mental and emotional well-being. They can also discuss the parent's willingness or unwillingness to engage in recommended treatments or interventions. But what should these witnesses testify about? Essentially, they should share their observations and experiences related to the parent's behavior and its impact on the child. This could include instances of neglect, abuse, or erratic behavior. They might discuss the parent's inability to provide a stable environment, their failure to meet the child's basic needs, or their disregard for the child's health and well-being. Remember, the goal is not to vilify the other parent, but to present an accurate and complete picture of the child's situation. Witnesses should speak truthfully and objectively, focusing on the facts. In conclusion, witness testimony is a powerful tool in custody cases. It can provide a third-party perspective on the child's situation. From teachers to doctors, neighbors to relatives, each witness can shed light on different aspects of the child's life, helping the court make an informed decision that prioritizes the child's best interests. Witness testimony can provide a third-party perspective on the child's situation. Gathering evidence is one thing, presenting it in court is another. How do we do this effectively? Indeed, presenting evidence in court is not as simple as showing up with a pile of documents or a list of witnesses. It requires careful planning, organization, and strategy. Let's delve into some ways to do this effectively. Firstly, it's crucial to understand that your attorney plays a fundamental role in this process. They are your advocate, your voice in the courtroom, and they know the ins and outs of the legal system. They can help you determine which pieces of evidence are most relevant and how to present them in a way that will resonate with the judge. They'll also ensure that your evidence is presented legally, adhering to all court rules and procedures. It's always wise to lean on their expertise. Next, organization is key. In the world of law, disorganization can lead to disaster. Imagine trying to make a crucial point, but you can't locate that specific document or photo that supports your claim. You need to have all your evidence ready and organized in a manner that allows you to present it smoothly when needed. This can be as simple as maintaining a binder with tabs for different categories of evidence, or a digital folder if your court allows electronic submissions. Now let's talk about focusing on the most relevant evidence. It's tempting to present every single piece of evidence you've gathered. After all, you've spent so much time and effort collecting it. However, not every document, photograph, or witness statement will carry the same weight. You must prioritize the evidence that directly supports your claim of the other parent's unfitness. For instance, a documented incident of neglect or abuse will hold more weight than a casual observation of the other parent's messy house. Remember, quality over quantity. Also, it's important to remember that presenting evidence isn't just about what you show or say, it's also about how you show or say it. Maintain a calm and respectful demeanor, even if the process becomes emotionally charged. Your attitude and behavior can also be a form of evidence, showing the court that you are a mature, responsible adult. Lastly, bear in mind that the court's interest lies in the child's best interest. Every piece of evidence you present should tie back to this fundamental point: how the other parent's unfitness negatively impacts the child. The judge isn't interested in personal disputes or grudges. They want to see objective evidence that supports your claim. In conclusion, presenting evidence in court is a delicate balance of strategy, organization, and focus. It's about working with your attorney, prioritizing the most relevant evidence, and always tying back to the child's best interest. Remember, your ultimate goal is to protect and provide for your child. Presenting your evidence properly can make a big difference in the court's decision. We've learned a lot today about proving a parent is unfit in a custody hearing. This is not a journey anyone wishes to embark on, but it is a necessary one for the well-being of a child at times. To navigate these complex waters, we have broken down the process into comprehensible steps. First, we explored the criteria that define an unfit parent in North Carolina. These include neglect, abuse, addiction, and any behavior that puts the child's safety and well-being at risk. Understanding these criteria is essential, as it sets the foundation for the kind of evidence you need to gather. We then delved into the process of gathering evidence. This is a crucial step, as it forms the basis of your case. It's important to remember that evidence should be factual and relevant. This includes any records or documents that reflect the unfit parent's behavior or circumstances. Documenting incidents is another critical aspect. Writing down any instance that highlights the unfit behavior of the other parent can be powerful evidence. It's essential to be detailed and specific in your descriptions, noting dates, times, places, and any other relevant details. We also discussed the role of witnesses in your case. People who have witnessed the unfit behavior firsthand can provide testimony that strengthens your case. These could be teachers, neighbors, or family members who have observed the parent's conduct. Finally, presenting your evidence in court is the last step. Here, it's all about how you communicate your findings to the judge. It's not just about what you say, but how you say it. Be clear, concise, and respectful. Your lawyer will help you prepare for this, ensuring that your evidence is presented in the most effective manner. As we conclude this journey, let's not forget why we are here. This is about the welfare of the child, which is always the court's top priority. Gather your evidence carefully, present it effectively, and always work towards the child's best interests. Remember, the welfare of the child is always the court's top priority. Gather your evidence carefully, present it effectively, and always work towards the child's best interests.